thank you everyone for joining us today. I hope the day is starting well for you. My name is Brent Greers. I'm a local attorney here in Grand Rapids, general practitioner with a focus on business and estate administration. What we're going to talk about today are the legal rules that you need to know and understand regarding a new business entity or even an existing business that you're trying to formalize or bring to the next level. And so as we go through these slides, please feel free to ask questions, take notes, and we can go over anything you may have questions on in greater detail toward the end. Not everything is going to apply, obviously, to every situation, but a lot of what we're going to talk about does generally apply to any business, or at least are considerations that you as a business owner should know and understand and be prepared to make appropriate decisions for your business. First step, and some of you may be further along in the journey than others, but the first step, of course, is to, if you are going into business, deciding on what legal entity that business is going to be. There are several choices to make. Primarily, we're looking at your personal liability, as well as some tax considerations, although as a new business, that's not usually a primary driving concern, but it is something to keep in mind down the road. I'd also add that you can change entities as your business develops. You look at a big corporation like Meyer, for instance, pretty much nothing that we're talking about today would apply to a huge corporation like that, but they weren't always 250 something stores. Every business starts as one, person or one building or one grocery store. And those considerations are different, but they also mature as you grow along. And so as you go from maybe one storefront or one person, you add locations, you add employees, you'll see that your needs, particularly concerning liability and tax considerations, will change over time. That may necessitate a change in entity. And if that, I'm sorry, yes? Did someone have a question? Oh, okay.
No, Brent, I think that was just some background noise.
Oh, okay, I'm sorry. Okay.
Nope, no worries.
So, along with those lines, we're talking about, like I said, liability and taxes, but also it's important to establish your credibility and professionalism as a business. And so your choice of entity can help in that regard. Oftentimes people see at the end of a business name, PC, PLC, LLC, things of those natures. And that in a lot of people's minds establishes credibility. It means that you're a legitimate business versus someone, doing something on the side. Further, for some programs, for some grant making potential, for some loans, things like that, your choice of entity matters in those regards. And so it's important to, take what you're doing, your personal situation, and your business idea, and really consider what choice of entity you enter into in the initial part, but also keep in mind that can change over time. Each entity too, I would say does incur different costs and fees. You are, by making a choice of entity, I should say, you are establishing yourself with a government body. And so it ranges from county registration, in the case of maybe a sole proprietorship, doing business as DBA is what it's sometimes shortened to, all the way to the state level for LLCs, corporations, and everything like that. There's various documents that need to be filed with those various government entities that all come with their own fees, of course, and tax reporting responsibilities. The common choices, of course, you probably heard, like I said, sole proprietorship. That is the default designation that you have when you say, I am holding myself out for business. It can be as simple as a one man, one woman, and a lawnmower going door to door, mowing people's lawns. That's a sole proprietorship. Without doing anything else, you have a sole proprietorship. Now, even with that, you can, there is a way that you can register that with the county. Things like that. You can also get an EIN number, which helps with banking purposes, creating a bank account in the name of your business, things like that. But it really doesn't do anything else beyond that. And that's where the limited liability company comes in, LLC. That's kind of the median, I would say. That's kind of that fits most people's concerns and situations. And it's a simple filing with the state to create the LLC. And again, just like the sole proprietorship and all these other entities that we're talking about, will allow you to create a bank account in your business's name, things like that. The distinction, though, is that unlike the sole proprietorship, the limited liability company does carry, as the name implies, some liability limits as to your personal assets. And we'll talk about that further. The other common choice is a corporation. And again, aside from liability protection, that carries some tax benefits. It's double-edged sword, really, because it gets a lot more complex when you're looking into a corporation. And again, that's usually a situation that you want to enter into, when you have a good revenue stream. Usually like a six-figure or more income stream consistently, because there are some tax considerations that go into a corporation. And if you think about it, sole proprietorship, like I said, is you're one man, one woman holding themselves out, doing business, whatever that business may be. A limited liability company may be, now you have a storefront, you have a couple employees, you're a small business. A corporation, if you think about it in the grand scheme of things, that those are your Myers, things like that, where things get a lot more complex. You have accountants working for you, you have attorneys working for you, things like that. There's a lot of moving parts that go into that. So if you think about it in kind of that scale, everything from one man, one woman on up to, your big companies and corporations, that's kind of the range of choices of entities. And there's some other ones to consider too that usually don't apply to most situations. And we're not really going to go into that at this time. You may have also heard of a partnership. Partnerships are literally that one man, one woman joins in with another man and another woman and go into business together without any formalized documents being registered with a county or state entity. It's really two sole proprietors coming together for a common business purpose. Generally, those are not recommended because a partnership is very much how I often explain it. It's very much like a marriage. You shouldn't enter into a partnership or any business dealing, certainly with someone that you don't trust anyway. But it's fraught with risks. I mean, you're dealing with people at the end of the day, and people are inherently flawed. And so if you are going into business with other people, yes, you can form a partnership. Yes, you can formalize that with a written agreement. And that certainly would be something that I recommend if you're going this route, just so that everyone is clear from the start when things are good, what would happen in the event of, because in the event of happens to all of us, happens to every business. And so it's important if you are entering into any business with any other person that you have that discussion from the start, including as early as what are we going to call ourselves, how are we going to be formed, and putting that on paper, even in the case of a partnership. A lot of people, when they go into business, are obviously concerned with liability, and they hear oftentimes that if you create an LLC, you can basically do whatever you want and not be sued. And that is absolutely not true at all. You can't just pay $50 and call yourself an LLC and go out and drive recklessly or damage property or anything like that and think you're not going to get consequences for it, obviously. What the limited liability implies is that your investment in your business is what's at risk and not your personal assets. And so the LLC protects your business from liability, and your personal liabilities don't stand for anything that happens with your business. So for example, you have a storefront, someone slips and falls in the wintertime, walking into your business, they sue your business if you're an LLC, and you don't have to worry about your house or anything like that. But you could, your business insurance, everything like that, everything associated with the business could be at risk in the event that something like that were to happen. But it does protect you and your personal assets. And so it's a great, like I said, median entity to choose from because it does offer some substantial protections for very little expense. But it's not a get out of jail free, hey, I'm an LLC, you can't do anything to me. That's not how it works. The bad news, of course, in addition to what you'll see on this slide, the bad news is that it does not protect you from personal liability for your negligence. So again, if you are operating a business, but you do something outside the scope of the business to cause injury or damage to someone, the LLC is not going to protect you anyway. The interesting case is with personal service businesses. Sometimes a sole proprietorship is sufficient because the best way, even with an LLC, to protect yourself from lawsuits, which is the primary risk that we're talking about here with liability, someone suing you in court for money. The best way to safeguard against something like that absolutely is insurance. Whether you're an LLC, a sole proprietor, or even a corporation, you should have the necessary and proper insurances in place to cover the event that negligence happens or anything like that. I'd also say that limited liability does not cover intentional actions. Intentional actions would be things like crimes. If you drive drunk while you're operating a delivery service, that's an intentional situation that not even your insurance is going to cover because that's a criminal act. Insurance doesn't cover criminal acts. The other situation that we often run into with limited liability is that it does necessitate that you retain an attorney in the event that you're sued. And so unlike a sole proprietorship, if someone sues you in small claims court, for instance, saying that they paid you $500 to perform a service and you didn't perform that service, if you're an LLC, you have to retain an attorney to represent you because you, as the owner, cannot represent the LLC in court unless you're a licensed attorney. And so sometimes you can find yourself trying to do the best thing sometimes carries additional costs, unforeseen costs. And that's one of them that oftentimes catches people off guard. I see this a lot of times with landlords that I represent. They will put their rental property into an LLC. They have to evict someone or someone sues them for something that happens in that rental house. Now, instead of going to court and representing themselves, they have to get an attorney to represent them. But that's a small price to pay, again, for the other benefits that come with being properly registered and operating. What a lot of people also don't understand is, again, unlike the LLC or the sole proprietorship, an LLC requires you to do something. All these other entities, aside from a sole proprietorship or a partnership, requires you to do something, and that's doing something involves paperwork essentially and filing it with the right authorities. You can't just hold yourself out as an LLC. And so it comes with filing fees and having your documents properly filled out and completed and signed and everything like that. And also to avail yourself of the limited liability, even when you do those steps. So you fill out the necessary paperwork, file it with the state comes back with that recording saying, yes, we recognize you now as an LLC. You still have the obligation going forward to continue using it. If you don't use it, you effectively lose it. And by using it, what I'm talking about specifically is all your business dealings need to fall underneath that limited liability company. And you're signing your name to documents, to contracts, to leases, things like that, not as you in your individual capacity, but you as a member, you as the owner of this LLC. And so this screen will show you some examples of how to sign documents. Again, you never want to hold yourself out if you do have an LLC or a corporation. You don't want to hold yourself out or sign anything dealing with your business in your personal name. Yes, every business entity does have people behind it, but the entity, when we're talking about really creating a legal entity, we're talking about creating a separate body. And it's hard to conceptualize because we're used to thinking of bodies as in people, but you're creating a separate entity that will live apart from you, and really you're divorcing yourself from your business by creating these entities, and that's where the protection really comes into play. Now, again, because there are some ongoing obligations, it is certainly possible to lose the liability protection. There's a concept called piercing the corporate veil. And so it not only applies to corporations, but also in the standpoint of limited liability. And by piercing the veil, what it's referring to is that your cloak of protection, if you will, is only there to the extent that it covers proper business practices and actions. And so if you step outside of that, you are allowing for that veil to be pierced. One way of doing that, certainly going along with what we just talked about, is doing things in your personal name and not on behalf of the entity. But also, again, you as the individual doing something intentional, committing fraud or crime toward anyone, whether it's a customer, vendor, or bank. And also, and where this commonly happens with small business owners, is commingling assets. You get an account, you start off trying to do the right thing and have a separate business account under a separate name, separate EIN number, and everything like that. Business goes well. You're busy serving the customers or clients, whatever the case may be. Money's coming in. Next thing you know, you lose time to properly account for everything. And next thing you know, you're paying your light bill, your household light bill, with your business account, or you're buying groceries for your family with your business money, or you're doing this, or you're buying that with your business account, or vice versa. Now you're mixing personal and business together, and you lose the protection of the limited liability. So now if something happens and you get sued, now everything is subject to risk because you don't have that big veil of protection over your personal assets. There are other ways to protect against liability, namely waivers, disclaimers, and product warnings. However, there are a lot of provisions that you need to be aware of. And if you are going to institute any of these things, and in some businesses, they would actually be required, you absolutely should do so in consultation with an attorney. waivers and disclaimers in particular, for instance, you can't just, have people sign a piece of paper that says, you're not responsible for anything. There are laws that apply to how these waivers and disclaimers, what they must say and what they cannot say. There's a whole body of law called the Uniform Commercial Code that applies particularly when you're selling products, that talk about waivers and disclaimers and product warnings. But even in service businesses, there are some things that, like I said, you can waive and some that you can't waive. And including, you got to consider who can do the waivers. Waivers would only generally work for known or foreseeable risks. So, oftentimes you'll see, if you go to like some sort of outdoor activity, sports activity or something like that, you'll commonly see, waiver forms that say, we're not responsible for, personal injury or anything like that, because it's associated, or it's a foreseeable consequence of participating in that sport or that activity. You can't use that same language, for instance, if you're a barber. You can't say, hey, I'm not responsible if you die in my chair, because something like that sort of outcome is not a foreseeable consequence of getting your hair cut. And so you have to tailor these waivers, disclaimers, and product warnings to your particular business. And you absolutely should do so, again, in consultation with an attorney, but also your insurance carrier. When you have proper insurance in place, oftentimes those companies kind of have language that they want to see. Sometimes they'll even mandate that you include certain language in order to benefit from the coverage. Again, simple is better. Anytime, and this is just kind of a standard legal concept that applies not only to business, but just across the board. Anytime you draft something and you have someone else sign it, or whatever the case may be, and it becomes an issue before court, the court is generally going to decide that, the drafter is responsible for making sure that the other person, understands it, to put it quite simply. And so any ambiguity, so if you just write and it's not coherent, or it's not very clear what exactly the person is signing, that ambiguity is actually going to be held against you as the drafter. So again, it's incumbent on you, and particularly when you're in business, to do this the right way, make it clear, make it simple, so that there's no ambiguity as to what people are doing, that can be argued in court. And again, the best practice is to have someone help you with that if waivers, disclaimers, or products apply to your certain business.
Brent, we did have one question come up
Sure.
in the chat box, real quick, just before we continue on.
Sure.
And it's from Leah. So Leah, if you want to unmute yourself and kind of expand on your question, but she wasn't able to see the bottom of the screen when we were talking about not to sign as an individual, but more as the member of the LLC. So could you maybe just go into that a little bit more, and what you meant by kind of separating yourself from
Absolutely. So, and that kind of dovetails with this point that I just made. You want to make everything that you put in writing real clear as to who's doing what and how. And so part of that is, if you are signing, if you are a business entity, you sign everything on behalf of that entity and not as yourself as an individual. And in writing, the way that is implied is by stating as such. And so instead of at the bottom, we've all probably signed leases or employment contracts, or service contracts, whatever the case may be, and we're just used to signing our name. That works in the day-to-day situation for your personal business, of course. But when you are actually engaged in business and you are signing a contract on behalf of your business, it's important to not only say, my name is Brent Greers, and sign as such. You need to indicate that my name is Brent Greers, signing on behalf as the owner of Greers Law, PLC. And that makes it clear in writing that you are not signing in your individual capacity, because what happens is that if you sign in your individual capacity, let's just say for a contract, for instance, you know, you agree that you will pay $500 and you will receive, you know, 10 baskets of eggs or whatever. The person who supplies the eggs gives you all 10 baskets, and for whatever reason, you don't pay the $500. If you just sign in your personal capacity, just your name, that person could sue you personally for that $500 instead of suing your business. And so different defenses and situations may apply in that regard. Similarly, for leases, for instance, if you go and enter into a commercial lease for retail space, for instance, it's important that you're signing that lease on behalf of your business instead of in your individual capacity, because if you go out of business, that landlord could say, well, you signed this lease personally, so even though your business is no longer around, you're personally liable for the balance of this lease. And so again, there's ways of doing that in writing, and commonly it's a simple addition of just indicating that you are the owner of this entity and you're signing on that on behalf of that entity, and that you're authorized to do so. And so people authorized to do so are commonly, obviously, if you're the only business owner and you have an LLC, you'd be the sole member. And so, of course, you'd have authority to do so. And you just sign as such, Brent Greers, member of, you know, or sole member of Greers Law, whatever the case may be. Does that clear up the question?
Yes, it does. Thank you.
Okay. All right, so moving on to more fun aspects of creating a business and an entity, picking a name. Your name can be anything that another business is not already named. And so one of the benefits of going through and creating an entity and registering with the state is that the state system will actually kind of do this work for you, but you'd also want to do some prep work before you commit to a name. But it keeps track of every business that's registered in the state. And so it will not allow you to register a business name that's already in use. And so once you develop a business name and you go through and create this entity, you can be assured that no one else will be able to come in and start operating as West Michigan Adventure Tours, for instance, if that name's already taken. And so you have some protection in that regard that you are going to be the only West Michigan Adventure Tours in the state of Michigan when you properly go through this process. You can also do this, and you should do this beforehand, just by going on the state's website and searching for business entities, and it'll show you. Just pop in the name that you're choosing, and it'll show you if there is already another business like that. It'll bring you right to the page of that business entity, and so then you know you'd have to come up with a different name or whatever. And that applies statewide. So you can't just, if another entity is already in existence in the Upper Peninsula, for instance, you can't create one here in Grand Rapids. It applies across the state. And so that oftentimes though is the fun part of creating an entity is developing the name. Other than those limitations, you're free to call yourself whatever you want. In a lot of cases, it's fine to, use your last name and what you do. So sometimes people will say, I'm John Creative or whatever the case may be. I mean, that's fine. I mean, there's really no limitations other than you can't obviously be the same name as someone else. All right, so for example, can you file articles of organization for a new LLC under the name West Michigan Adventure Tours? And this kind of goes back to the same, the previous fact scenario. Like I was mentioning, you can if it already exists in the state. If so, what name rights go with the filing? And again, if you are the first to be called that, no one else can jump on that. Now, assumed names are kind of the same concept, but they apply particularly to sole proprietorships and partnerships. And so there's much more limited protections as to your name. Sole proprietorships and partnerships can't be registered on the county level as a doing business name. And you can also, even as an LLC, you can file separate assumed names under that LLC. So for example, sometimes people will file an LLC in the name of John Smith Consulting, and then they will also file a certificate of an assumed name for John Smith Towing or something like that. And that operates under that one LLC, but that one LLC can have several different names that are legal to that. With a sole proprietorship, you have to register with the county for each one, and that would not create a statewide protection. Although, smart people who are, really kind of looking to create bigger entities, they are going to do their due diligence and discover, no one wants to have, the same name as another operating business for various reasons. Not only do you want to be unique in the marketplace, but you also don't want to run the risk that, John Smith Towing in Grand Rapids is operating foul compared to, and you're John Smith Towing in Flint, and you're doing the right thing. You don't want people to start, associating you with that other company. So there's many reasons to avoid having the same name. And again, doing your due diligence and checking all the records to prevent that is absolutely the best thing to do to avoid that. When you create an LLC or a corporation, it's important that you do also incorporate the proper initials at the end, so that, again, that lets people know that you are an LLC or a corporation. And that goes back to an earlier point we made at the start about legitimacy. Now, I will say, and you probably all experience this, just because someone is or a business is incorporated or an LLC is certainly no guarantee of customer service or proper business practices. We all know examples of businesses in existence that are just not doing the right thing. But in a lot of people's minds, again, when they see that INC or LLC at the end of the business name, that does connote a certain level of legitimacy. They know that or they may not even know, they just may assume that, you've done more than just, again, you're operating out of your bedroom or something like that. They don't know anything other than that. So it does bring some legitimacy, but that also applies a responsibility to make sure that you are always putting your business name with those proper designations, particularly on legal paperwork, contracts, leases, things like that. All right, so how do you go about doing this? Again, usually it's just a simple matter of filing paperwork, and that's the bare bones requirement. That's easily found on the state's website. It's really super simple to fill out and send into the state, and they will send basically a recorded copy back saying that, acknowledging that they've received it and it's registered. Now, once you do that, every year there are additional reporting requirements in the form of annual reports. And so if you don't do so, usually February 15th is the deadline every year. If you don't do so, you have to pay a late fee. And if you don't do so for 3 years, then they just take it out of the system. And of course you lose, to the extent that those annual reporting fees are not paid, you lose the benefits of the LLC, because now you're operating out of compliance. And so it's important to keep up on that. It's really easy to do. You get notice of it. They usually send out those notices in November for that February 15th deadline. So you have a good 3 or 4 months to make sure you need to pay the proper fees. You can do it all online. It's super simple. Now that's the easy part. The harder part is, particularly if you're going into business with other people, is creating the operating agreement. And there's really no, there's really, I mean, there are templates out there, but you really want to find something and create something that's particular to your situation. So that's oftentimes where attorneys get involved. I'll write draft an operating agreement after consultation with the owners about how they want their business to operate. Also bylaws, things like that. If you have a board, there's various other documents that are required beyond just the bare bones, what gets filed with the state. And again, those are governing documents about how you're going to operate. And those are kind of more or less internal to you and particular to your business situation. But they're very important from the standpoint, again, if there becomes a dispute between business owners, what are we going to do? Very similar to getting married and all of a sudden you get divorced. In that case, there's laws governing, what happens with assets. In the case of a dissolution of an entity or fights between business owners, there are rules too that kind of dictate that. But you usually don't want to rely on that. You want to create a situation, again, when everything's going good, is the best time to put things in writing about how we're going to handle challenges that will come one day, when everyone's on the same page. And so you put that in writing in the form of an operating agreement so that everyone's clear about everyone's rules or roles and responsibilities, who paid what, who's owed what. It all is put out there on the table and put in writing. And so that's really the harder part of creating the entity. And it's really kind of an addition to that, but probably more so important for the general operation of your business. And so you really want to put some thought into how that looks.
Brent, we have a question in the chat box, and it's interesting. I'm curious what you have to say about it. Is there a situation that a business would start out as a corporation and not as an LLC or sole proprietorship?
Oh, absolutely. You would probably want to think about doing so if, kind of out of the gate, your revenues are going to be such, 6 figures or more. That oftentimes is a situation that an accountant or a tax professional would recommend after consulting with them and looking at your business plan. What's going on with your finances and everything like that. They may make that recommendation at that time. Just very generally, some of the key differences between an LLC and a corporation is that, an LLC is what's called a pass-through entity. So everything you earn flows through on your personal taxes. Versus a corporation, you have dividends as an owner of the corporation. Just as if you own stock in GM or wherever, you get a dividend, every so often. And under our tax code, under current tax law, dividends are taxed differently than income. But you'd also be required to pay yourself a reasonable salary. And so you would actually give yourself a W-2 as an employee, just like anyone else that works for a company. You get a W-2 at the end of the year with your wages, and then that gets reported on your personal taxes. And so that's why it's very much so, if your business falls into a situation where, again, you're going to be making a significant amount of revenue out the gate, you may start off as a corporation. It's relatively rare to go back to an LLC from a corporation, although it's possible, and there may be circumstances where that may be necessary. For example, your business shrinks or dissolves to the point where you can't pay yourself a reasonable salary. Reasonable salary is kind of defined or managed by the IRS. you using a whole host of factors, but essentially, to make a long story short, you can't, a reasonable salary is not $100 a year. They look into, what type of business you're in, to develop what should be a reasonable salary for that position. And so, and if your business just cannot pay that, then there may be a need to move down to an LLC. It's much more common to start off as an LLC and then become a corporation as your revenue grows to the point where it makes sense tax-wise to become a corporation, so that then you can, you're making so much money that it may make sense to pay yourself a salary and be taxed under your personal tax bracket, and then also take additional money as a dividend from the business and be taxed on that under the current, I think it's 20% or maybe 15% taxes for dividends. But that's all incumbent again on revenues and stuff. Any other questions on that?
I don't think so. Chatbox looks good.
Okay. Some other things before creating an entity, and this is just a general tip, of course, you should never sign blank forms or anything. Signing on behalf of an entity that is not yet formed, because obviously if it never becomes formed, you don't have any protection under that sort of thing. If you have 2 or more people that you're going into business with, it doesn't hurt to get agreements in writing from the start. Again, that can only, it's always best to make agreements when everyone's happy and everyone's kind of, in the creative process, trying to make things work and everything like that. And having those kind of more difficult conversations then, instead of when things really go wrong. And then everyone's looking out for their best interests. Some other things to keep in mind, and this again depends on what sort of business you're going into, but you got to keep, be aware of zoning requirements. You can't operate just any sort of business anywhere you'd like. If you're in a residential area, they're not going to allow you to operate a gravel pit, for instance, next to within a residential area. Certain areas are zoned commercial, and even within that, there's levels to that zoning. Very similar to, you see that with houses too. I mean, there's some neighborhoods where you only see single family homes for a reason, because the zoning code doesn't allow for apartment complexes, for instance. But even more granular than that, there are certain types of businesses that cannot operate in, again, residential zones or even certain commercial areas. There's industrial areas, things like that. So it totally depends on what kind of business you're operating, where you can actually operate from. Some businesses require an actual business license by the city. You see this commonly with, street vendors, for instance. They're required to be licensed by the city. Snowplow dryers, if you want to operate a snow plowing service, you actually have to be registered with the city to do so. And usually in those situations, there are some added benefits to doing so. And commonly that opens you up to become a list of recommended providers that the city provides to various entities and stuff. So there are some benefits to that, but just be aware that depending on your business, you may have some licensing requirements with the city. Also with the county, with food service, if you're serving food to anyone for money, you're going to have to deal with the health department and be properly certified and everything like that. Understandably, you don't, no one wants someone serving food to people who are not complying with proper health standards. and that's a whole different situation. Sometimes people want to follow with that, where they're known as the person in the neighborhood. On Sunday you go and get a takeout plate from them. That's fine, but the moment you start, serving food, you're opening up a stand and you're serving food for money. There's certain requirements that have to be met. Otherwise, you can run afoul of that real easily. If you're selling goods, there may be sales tax requirements, so you have to be registered with the state for that, so that the sales tax can be properly reported and paid. There are certain licenses for certain professionals. So obviously, if you're a tradesman, that you have to have the proper license in order to do certain things, in order to pull permits and everything like that properly to perform your work. And you have to make sure you have the proper licenses for that. Personal property statements. There's businesses get taxed on their personal property, and so there's reporting requirements for that, for the city as well as the state. Annual reports we talked about, that gets filed with the state if you're an LLC or a corporation every year, and there's a filing fee for that. Certificates of assumed names, that's particular if you are sole proprietorship, and if you are, and nothing that I say today should dissuade you from being a sole proprietor. That's a decent choice for some people. I was a sole proprietor for a number of years before I became a PLC for various reasons. But if you are going to go that route, it does make absolute sense to file this assumed name certificate with the county, just so that the name's on record. And again, that's again a sign of legitimacy that you are a legitimate business owner. Now, on the tax tip, you should engage with a tax professional or an accountant early on. Again, they will help you make that decision about what the right entity is for you. In particular, if your situation is going to be such that they recommend a corporation, that's important stuff to know before you commit to an entity. And they'll also help you get an EIN number, walk you through what are the proper tax forms. They'll walk you through the sales tax requirements, everything like that, how to set up your systems to properly account for everything. Because the last thing you need as a business operator is, everything is going great according to plan, you're making money, but your books are slipping, or you don't have any books at all in the worst case. And then it comes tax time, and you're going to be in for a world of hurt trying to, comply with what's necessary. So the best thing to do is have that conversation before that money starts rolling in, so that you know where it's going and you have a system in place to keep track of it so it can be properly reported. Because, if you're engaged in business full time, unless you are already trained as an accountant or a tax professional, you don't need that added burden of trying to figure all that stuff out in addition to running your business full time. And so it's important to consult with someone and have that person on board your team. Also, insurance. Again, the choice of entity, offers a lot of protection. The right choice of entity and operating within that entity offers a lot of protection, but it's no substitution for the right insurances. And so insurance is your absolute best defense against anything going wrong. That is the purpose of insurance. And so, liability insurance, if you're a professional, of course, you probably have some malpractice liability insurance requirements, or you have those policies available to you to cover your providing of services. Workers' comp, if you have employees and you're engaged in situations where they may be hurt, you need a workers' comp policy in place. Property insurance, if you have a storefront, or even if you lease a storefront, you probably want some sort of general liability or property insurance to cover the event that someone throws a tire through your window, or someone slips and falls in your doorway in the wintertime, things like that. It's important to note, even if you're operating out of your own home, your homeowners or renters insurance probably will not cover business losses. So even if you're operating out of your home and someone is visiting your home to, you're a barber and you cut hair out of your house, and someone's coming to your house to get their hair cut and they slip and fall on your front steps, they're there for a business purpose, and your homeowner's insurance may not cover that. You want to make sure that you have the right insurances in place to protect yourself. Contracts are a necessary part of business. They include not only service contracts, I'll pay you X amount of money to receive this, but also bank loans, paperwork, leases, confidentiality agreements, non-compete agreements. Those are all forms of contracts that need to be in writing and done properly so that everyone's clear. In addition, if you're engaging customers or clients, it never hurts to have agreements in place in writing. You hear on the news all the time of people, and it seems to happen every summer, people hire contractors to do work on their home, and you hear on the news some story from the news investigators talking about, I gave this contractor $5,000 to do my roof and they never showed up again. And usually in those situations, you'll also find out that there's no writing in place. They when they gave that $5,000, the contractor never gave them anything in writing, with their name. They never kind of did that due diligence. And so it's important, not only from a legitimacy standpoint, but also to protect you, to have service agreements in place, to have contracts in place with your customers and clients, so that, if you say I'm going to do X, they can't come back and say, well, you told me you're not only going to do X, but Y and Z as well, and you didn't do it. Everything's in place. What you're going to do, when you're going to do it, and how much it's going to cost should be in writing. So there are some common mistakes that you should avoid if at all possible. One of the things is, mixing personal and business assets. We talked about that, commingling funds. And that sometimes it's a habit that's hard to break, because oftentimes when you're first starting out and you're the one running the show, it will seem at times that the business is personal, but it'll absolutely benefit you long term if you can get in the habit of really separating your funds, creating a business account. Everything from the business goes into there. All the expenses are paid out of there. And then you pay yourself, and you can decide, with the exception of, well, even as a corporation, you can kind of decide on the frequency and how much of when you move money from that business account to your personal account. So you can effectively pay yourself. If you want to pay yourself weekly, monthly, whatever the case may be, you can decide that based on your finances. But then all of your personal finances, your personal bills, everything like that should come out of your personal account. It's just a good practice to get into, to separate the two from the get-go. You also need to think about insurance, all these other things that oftentimes get lost in the flow of, I have this great idea and I want to get it out into the marketplace. There's a lot of other things to consider around that. And it's great to have professionals involved to help you think about those issues before you get too far in. And that's really where our value comes in, because obviously you're the one with the idea, and you're the one with the work ethic to make it happen. And we can walk alongside you to make sure that your other bases are covered. And again, if you have more than yourself, you have to think about these things. These can be incorporated in ownership or partnership agreements, operating agreements, things like that. But life will continue to happen even once the business is off and running. People get mad at each other. People embezzle from each other, people die, other people get involved, people quit, you know, any of those things, and they all need to be kind of accounted for in writing as to what would happen if my partner dies. Now you are solely responsible for keeping this business afloat. What happens then? What happens if this person's wife or husband wants to get involved? Things like that. So all that stuff needs to be accounted for. When you should call me or an attorney, again, I handle the legal end of things. And so a lot of what we talked about today is pertinent to legal questions. And that's absolutely when you want to engage with an attorney, particularly when it comes to liability, and, operating a business appropriately with zoning, with licenses, things like that. Make sure you're legitimate on that. Some of the other issues we talked about with insurance and taxes and everything like that, those are accountant questions, and you should absolutely also engage with an accountant. And again, if you have more than yourself, a lawyer can certainly sit down with the both of you and make sure that we put together an operating agreement that you both can agree to, and have it signed properly, and making sure that there's